Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio super lawyers. More answers, more help, more law on Fox 19.
Welcome back to More Law. We are talking about business and estate planning today. And Don, there was something you mentioned just before the commercial break that you wanted to talk about.
Yeah, I wanted Tom to tell us a little bit about, you got a couple of people live in an apartment. They don't have anything titled in the decedent's name. That is, no stock, no car, they don't own land, and one of the people pass. What happens if they never go to probate? They just keep on using the furniture and whatever cash they've got on hand, and they just carry on.
Well, actually the answer is nothing happens, because probate is a process that is designed to protect the potential heirs as long as no one complains about that, the untitled assets in their use. I don't see a big issue with that. But before we started, you did point out one thing to me in the particular line of law that you're in. If someone's in an auto accident or otherwise, it's still a good idea to have a will, because they might have much more money than they expected if their spouse dies from the results of a personal injury.
That's true.
So in all cases, I do recommend, at the very least, a simple will.
Even if you don't have much, suddenly a person's estate can be worth a lot.
Right.
If they died, let's say, as a result of a traffic accident, it was someone else's fault, and they've got large expenses and so on, suddenly they have an estate that's worth quite a bit.
All right, or inherit from their own family members, or any of another things, or win the lottery. Who knows?
There you go. But I'm all for that.
It's all right.
I'm a fan of that. Also, let us go now to More Law Connection, where Dan Moore is answering some viewer emails. Good morning, Dan.
Thanks, Deb. Today our first question is from John. He says, I'm throwing a football party and providing beer. Does this make me responsible for anyone's behavior? It's a good question. Football season, first game tonight of the Bengals. This is a question that comes up often. If you are not a liquor permit holder, that is, you're not selling beer for profit, you're considered a social host. As a social host, the law says you're not responsible at all for other people's behavior if they go out and do something stupid after attending your party, unless that person's a minor. If a minor's at your party and the minor drinks and does something and injures somebody or injures themselves, then you're going to be held responsible. So if you're at your house and you're throwing a party, just make sure minors aren't partaking. Deb, back to you.
All right, thanks a lot, Dan. Of course, we want to reintroduce our guest. Tom Cuni, how are you?
Just fine.
Good.
Thank you.
Everything's going all right here for you?
So far, so good.
Okay, great. Let us get to another call. Let's start with Deborah in Coleraine. Go ahead, Deborah.
Yeah, my question is, my understanding is if you have something wrote on a paper and you get it notarized, that stands good in court. And my second question is, do you have to leave your kids anything when you pass away?
Two questions, and I'll answer the first one. Something signed by a person and handwritten is called a holographic will, and it must be determined by the probate court in a separate proceeding that it is in fact an admissible will. Notarization adds nothing to a will. A will is, in Ohio, has to be witnessed at the end by two persons. Simply writing something on a paper is usually not a very good idea. The expense that you're going to have in getting it admitted to probate outweighs any savings that you might have. Your second question was, do you have to leave anything to your children? And the answer to that is no. There's difference when it's a spousal circumstance, but with children you do not, nor do you have any obligation to, but you must have a valid will in order to basically disinherit your child.
Okay. All right,
Okay.
great. Go ahead, Don.
And isn't it a good idea, if you're going to disinherit kids, to name them in the will, and so they're not pretermitted? It's not like you forgot?
That isn't actually what a good practice, and most people, in fact, do that with something inoffensive, such as I purposely made no provision for my son, Tom Cuni, although and then leave it at that instead of telling why you're not doing so. Okay. But yes, that's a good idea.
Okay, great. Let us go now to Linda in Covington. Linda?
Yes, I have some acres with a house on it and a rental property. And I have 3 children. 2 of my children already live on the property with their own acre. And my third daughter will live in this house when my husband and I are deceased. I was wondering how I can get the rental property in their names without going through lawyers. It's just a little confusing to me, and none of the children want to sell any of the property, and I just was wondering how I could do this.
Your thoughts for her, Tom?
Without going through lawyers is pretty much not an advisable circumstance. Real estate is a matter that is a public record for years. When we do a title exam, we go back 60 years or more, and in some cases that even farther, depending on the circumstances. Trying to do your own deed or trying to make your own conveyance of real estate is courting disaster. It's a relatively modest cost to prepare a deed to these children if you intend to give a present gift now to them. So my advice is, although you have some hesitation in dealing with attorneys, find one who does real estate practice and talk to him or her about that and a little bit of estate planning.
Okay, and that's a little peace of mind there for sure.
So a deed's $150 to $300, and fixing up a title mess is thousands and thousands, right?
I was paid, my firm was paid something close to $40,000 quite a number of years ago to straighten up a title issue resulting from a subdivision problem.
And that would be to save 150 or 300
yes,
bucks?
Yes,
Yeah.
it was a good savings.
Okay. Let us go back now to Dan Moore with another email question. Dan?
Okay, our next email is from Sandra. She says, a shelf fell off at a grocery store and hit my shoulder. How can I get to the store to pay my doctor bill? Now, there are two different ways to handle this. If all you want is the store to pay your medical bill, then you could submit the bill to the store, and the store typically may have an insurance policy that would cover that. The second way to take care of this is if you have a more serious injury with a more permanent injury or something like that, that you want to recover more than just your medical bill. In that situation, you have to prove more. You've got to prove that the store should have maintained the shelf in a safer condition. If you can prove that, then you can recover more. The rule really is, from a practical standpoint, is if you want to recover more than just your medical bill, you're going to have to prove more. Now, if you have a question, go to Fox19.com, go to the More Law tab, and click on the Send Us Your Questions form, fill it out, and submit it to us, and we'll do our best to answer your questions. Deb, that's all I have for today.
All right, thanks a lot, Dan. We'll take a break right now. We'll be back with more law today, talking about business and estate planning. The Ohio and Indiana Bar Associations require we give the addresses of the attorneys on the show, so here we go. Tom Cuni, Cuni, Ferguson, and LeVay on Springfield Pike in Cincinnati, 771-6768. Don Moore, of course, the Moore Law Firm, 1060 Nimitzview Drive, Cincinnati 45230, morelaw.com, or you can get all the information at fox19.com by clicking on More Law. Thanks for sticking with us. And Don, you had some advice for folks, some information about what people need to do as far as preparing if they're going to get a will.
Yeah, exactly. You know, when a person goes to have a will made, one of the things they're doing is they're paying for the attorney's advice. And you're going to help your attorney and reduce the amount of cost if you come prepared. So there's a couple of things, we wrote down a few things that you could do that would help reduce the time, make everything a little more efficient. One, a list of assets, specifically assets that are titled, account numbers, automobiles, real property, those kind of things you should have a list of with specific description, like it's a 1925 antique automobile or something like that. The other thing you should bring in is a list of names and addresses of your family members, those who will be taking or should be mentioned in the will. And then third, you want to make a list of specific bequests if you intend to do that. Not everybody does that, but a person may want their wedding ring to go to a particular son or daughter or some of the other assets. If you bring that list with you, it's going to cut the amount of time you've got to spend with a lawyer. But in point of fact, you really don't have to bring anything. Isn't that right, Tom?
Well, I was hoping you'd ask me that, and the answer is I typically do ask people to bring the information which you've discussed, but I don't like it to act as a barrier to that first
coming
interview, to coming in and doing it. And among the other things we're going to talk about is who are going to be the executors, who are going to be the guardians if you've got minor children, and these are all topics that should be discussed in some detail, and making that decision beforehand frequently keeps people from actually coming in to see us. So it's come in with a general idea of what you want. Let's talk. We'll prepare a draft of the wills, and we're going to talk a second time. This is a matter that requires some thought and some consideration by the client as well as the attorney. So
Very good. Thank
bring
you.
them if you can. If you can't, I'll still talk
Just
to you.
still come on in. Okay, let us check in now. I think we have Jenny in Cincinnati. Jenny, I think you had a question about debt as it relates to a will or estate planning?
Yes. If I have, my assets are more debt than they are asset, and I write a will my benefactors then incur that debt?
The answer is no, not if the estate is properly administered. Your beneficiaries and also the executor who is handling your will is charged with, or the executor specifically is charged with the responsibility of gathering the assets, selling them, and paying your creditors. Once that is done, if it's exhausted the money, there is no further payment nor liability by any person that is your beneficiary.
Okay. And Tom, we just have about a minute left in the show, but I think what we can all take away from this is the pros of getting a will outweigh what are probably the cons, and the cost. If people are afraid of $500, imagine what they're leaving behind if they don't take care of it.
That is exactly right, Deb. And the small amount of money that's involved in this, or I'm sorry, I shouldn't say the small amount. It is a significant amount of money to most of us, but it is well worth it if for your children, for your spouse, for your family generally, to make this investment. It's not a topic that everybody's really anxious to talk about,
Absolutely.
death and disability and all the other unpleasantness, but it's something that you should do.
Okay. Well, thanks for joining us, Don.
Yeah, there's a parting takeaway I want everyone to have, and that is there's a lot of ways you can cut costs and cut corners. Don't cut corners or cut costs with the will. Get a will, get it today before it's too late.
All right. Don, thank you. Tom Cuni, thank you very much for joining
Thank you.
us today.
Thanks a lot, Tom. Great having
And
you.
we'll be back with more law next Monday morning when we are talking about the truth about trial lawyers. Have a good week.